And we're good to go.
Good to go. May I proceed, sir?
Of course.
Okay, welcome to the commission. My name is Mike Sasso. I'm the chairman. And the way we're going to proceed this morning is I'm going to walk around the virtual room and each of our commissioners will introduce themselves to you and tell you where they're from. You will then have 4 or 5 minutes to make an opening statement. Then there'll be a question and answer period. And after the question and answer period, I'll watch the clock and I'll hold back 4 or 5 minutes for you to make some closing remarks. So with that, I'd like to, and Mike Sasso, I'm the chairman. My vice chair is Commissioner Amanda Carl. Amanda.
Good morning, I'm Amanda Carl. I work as in-house counsel here at Judah & Sons in Oviedo, Florida. Welcome this morning.
Thank you.
Commissioner Andy Bardos.
Good morning, Andy Bardos with Gray Robinson. I'm in Indiana.
Commissioner Lauren Blocker.
Good morning, Lauren Blocker. I'm in-house counsel at FIS and I'm in Ponte Vedra, St. Johns County.
Commissioner Citro.
Good morning again. My name is Vincent Citro. I am with the law offices of Horowitz and Citro in downtown Orlando.
Commissioner David DeArmas.
Hello, I'm David DeArmas in Orlando as well at Kramer, Price and DeArmas.
Commissioner Craig Dyer.
Hi, Craig Dyer, recently retired Chief Assistant Public Defender's Office, Daytona Beach.
Commissioner Carrie Eisenagel.
Good morning, I'm Carrie Eisnagel and I'm in Sanford.
Commissioner Scott Thomas.
Hi, good morning. Scott Thomas with the Burr Foreman Law Firm. I'm up in Ponte Vedra Beach, St. Johns County.
Ms. Savona, I assigned you to Commissioner Craig Dyer for your vetting, and he'll start the question.
Wonderful, thank you.
Did you wish to give her an opening statement?
Oh, I'm so sorry. I think I've had too much coffee. Forgive me. Please give your opening statement.
Thank you, Chairman Sasso, and thank you, commissioners, for having me here today and holding this via Zoom. I was very much looking forward to meeting all of you today in person, but fortunate for us, I think the Zoom format has kind of led us to work in our own ways. I've been home for the past few days, so I'm very thankful that I'm still able to be in the interview and be here virtually. So thank you for your service and the time that you've put into this application process, and thank you for interviewing us. Briefly, just to give a little bit about myself, I'm here in Orlando. I've grown up in Orlando, brought up by 2 wonderful parents, one of which immigrated from Italy and had no understanding of the English language. The other one, who was from a working class family, both came from backgrounds that really didn't have an educational founding. And both of them have now risen from that place. And they are both very wonderful physicians in the community. And I say that because there's certain things that I think they've instilled in me at a very young age. And that's perseverance of overcoming adversity, that's working through and understanding and respecting education and learning, and really doing what's right, even when that's difficult. For me, I'm here in front of you today as an applicant for the 5th District Court of Appeal. And that's because of my love for not only the law, but really also for appellate advocacy. It was the one class when I first took in law school that I truly fell in love with what would be a lawyer would be like. And I feel that my experience has shown that. I started and I focused primarily on appellate practice. I started in the Attorney General's office in Tallahassee, working on criminal appeals, where I got to deal with fascinating and ever-changing constitutional issues in the criminal realm, and really had the opportunity to grow as a young lawyer, focusing on so many different types of cases, as well as the amount of briefs and oral arguments that came with that. From there, I moved on to the Florida Department of Health, where I was the chief appellate counsel over the prosecution services unit. I got to work with over 50 prosecutors, working with them on their cases, on emergency action, other things of that nature, but really working on administrative law appeals. And now to where I'm at currently, which is in the civil realm, in the private sector. And working on different areas of the law, different areas of private sector, whether it's general liability issues, condominium, association, medical malpractice, wrongful death, all of those issues have really led me to where I am today. I'm very thankful for these experiences. And it's, again, the passion that I have that has led me to be here today. It's something that has been a goal of mine since law school. I set goals when I graduated, all of which ironically were appellate related. I'm thankful that my opportunities and experiences in the past have led me to become board certified in appellate practice. And I look forward to answering any questions that you all have for me today.
Thank you. Commissioner Dyer, proceed.
I want to thank you again, Ms. Savona, for being here today. I note that you're just over the top of 10 years here as a practicing attorney. Although you do have an extensive appellate background. You are presently working for who?
I'm presently working with Cole, Scott, and Cassane in Orlando.
Okay, pretty excellent firm. You've received raving reviews from everybody I've talked to, everybody who has emailed me. There are a few people who, I guess because of the way you are involved in appellate work, can't seem to remember who you are. However, I find out later on that's because there's like 7 or 8 attorneys involved in the appeal. You have a lot of support from people who are close to the governor. So I've been contacted by other people. I have, as far as your involvement here, what do you think that you could bring to this committee based on the fact that you only have 10 years as an attorney that would provide us a reason to send your name up over all of these people with so much experience?
Sure, and thank you, Commissioner Dyer. And it's truly humbling to hear what other people in the profession have said about me. It's something that I did not really expect, I think, in this process, but it's very humbling nonetheless. I think, again, going to what my experience has been in my over 10 years, even though it is maybe a little over 10, but nonetheless, it is over 10. And it is something that I'm very proud of. I think in my application, I think I noted the amount of appeals. And again, I think that's because in the public sector, I got to have so much experience so early on. I believe within the first 2 years of my practice, I wrote about 250 briefs. I think as of now, I'm on the verge of 500. So, and that's not to brag. I think that's to show that even though I may not have 20 years experience or may not have judicial experience, it really shows where I've focused my practice for those 10 years and why it's so important for me to be considered for this position. So I think it's that practitioner level of experience and just the sheer amount and the different types of cases I've worked on. Again, worked on criminal, I've worked on administrative, and I've also worked on civil. And throughout my administrative appeals at the Department of Health, and my civil appeals currently with Cole, Scott, and Cassane, I get to also work with the trial attorneys and work with them on issues that will come up at trial or on dispositive motions or on things that maybe we need to look at whether there's an interlocutory order to be appealed. So I think that experience would bring a good, I guess, be a good addition, I should say, to the district court.
Well, as a criminal trial lawyer, I have had a lot of experience with cases that I have handled at trial, and I've never done an appeal, that have gone up to the 5th DCA and been shot down on a PCA without any opinion whatsoever. So I'm very slanted in this direction, but I would ask you, do you believe the present 5th District Court of Appeals opinions as PCAs are concerned should change in any direction?
I think PCAs have their own right, and that's on a case-by-case basis. I think it's hard to make a determination in a vacuum on any type of cases, whether it's criminal or civil. I think based on my experience, Commissioner Dyer, when I was doing criminal appeals, I knew that there were a lot of issues that were on judgment of acquittal. The law on the judgment of acquittal was very well established, not only in the 5th District, but in all the other districts in Florida Supreme Court. And a lot of times those cases really came down to maybe the fact-specific issues. And a lot of times we would see PCAs in those cases, I think, regardless of whether you're on the side of the defense or the side of the prosecution. I think in those situations, if there's something that's a very well-established law and the facts really don't add to explain the law so that other people understand it, I think a PCA is appropriate. I think also PCAs I think are appropriate when there are preservation issues. And that's not just preservation issues on my opposing counsel side, but there are times where, of course, as an advocate, you face preservation issues because as the appellate attorney, you aren't the individual that tries the case and maybe you weren't there. And I know it's difficult at trial to always be in the mindset of let's make the objection to preserve it for appeal. So I think PCAs have their own right, but I also think written opinions have their own right. And it's something that if I were to be on the 5th District Court of Appeal, I would consider on a case-by-case basis and not give a rubber stamp to a certain type of case that would automatically receive a PCA.
Well, thank you. I have no other questions.
Thank you, Commissioner Dyer.
Commissioner Amanda Carl.
Good morning again. Thanks for joining us this morning. I have a question. I know you have some experience in criminal work at the beginning of your career, but it looks like the last 5 years has been 100% civil. Can you talk to us a little bit about how maybe the experience you had early on might be helpful? As we know, most of the appeals at the 5th DCA are criminal appeals. The majority of the opinions written are civil, but the majority of the cases are criminal. Can you explain to us if that experience will help you and also what you would do to kind of get up to speed in the criminal world if you were on the bench?
Sure. And I think that's a great question because I've kind of switched gears from the beginning of my career to where I'm at currently. So I think I'm going to start maybe with your last question first, is what I would do to get caught up to speed. I think the best way to do is read the case law, see what's changed. We know that there have been developments. I know that when I left the Attorney General's office, there are a lot of developments, especially in the 8th Amendment realm. And those were cases that I worked on exclusively in post-Graham cases or post-Miller versus Alabama. That's changed a lot. Specifically, there was a case that I was working on that went to the Florida Supreme Court that had tagged jurisdiction with another case. And that's when I went to the Department of Health. And I think it got overturned by the Florida Supreme Court. Things have clearly changed. I think reading up on case law and doing that, and also, reaching out to those in the community to say, hey, I remember this, I read this case. I want to make sure I'm up on the same speed. As an appellate attorney reading, I feel that I read more case law than I read books. I have a stack of books by my bed at home, and I always love to read them, but I find myself always going back to case law. So I think that's one way of doing it. I think also taking any additional type of CLEs related to criminal updates is always important. I found that those types of updates are really spot on with talking about what the legal issues are. And then I think if I were to be a member of the 5th District Court of Appeal, once you get back into that, I think criminal I've always enjoyed. So that's something that once you kind of get back into that rhythm, you start seeing it and you get more into a groove, and then you're up to date on that. So going back to your first question of my criminal experience at the beginning, I think it was the most beneficial thing I could have done to start my career. And that's my personal opinion. I don't think there's a specific path that everyone should follow. For me, it was getting down and deep into the 4th Amendment and the 8th Amendment. And those were the two amendments for some reason. I just would get those cases because they just spoke to me. I dealt with very difficult issues with gruesome crimes, with gang crime. And it really kind of builds you up to understand how to separate things from being able to work on a difficult case versus infusing your emotions into it. And not only the subject matter, but also I think the quantity. We had a large caseload when I was at the Attorney General's office. I believe at one point I had 30 briefs due a month. I did not file 30 briefs. I did take extensions, but I think I averaged maybe 3 briefs a week. It's a lot for not only a young lawyer, but for an appellate attorney. And that was something that I wanted to do. And so I would gratefully take on the challenges for maybe the more difficult cases that someone didn't want to do. I think that also prepared me, though, for where I'm at now in the civil sector or in the private sector doing civil work. It really helped me in terms of knowing how to manage difficult cases. I remember I had a cryptococcal meningitis case when I first started in civil practice. And I think the partner that assigned it to me, when they gave me all the binders, they said, well, I'm really curious how you're going to do this. And I looked at it and I said, oh, this is nothing. I've done all these, I've done these appeals that have been thousands of pages. And he didn't know how to respond. I think he thought it was, well, this is a new associate, even though I was 5.5 years as an attorney at that point. And so I welcomed the challenge and I really adapted to that because I do enjoy the intellectual challenge. Not only that the law brings, but also that my different practices that bring. And I think it's those two building blocks, as well as what's in the middle, which is the Department of Health. Those building blocks, I think, would really, truly help me in what is probably 50 to 60, maybe % of what the 5th District does, which is criminal. So I think that it's helped me to be where I'm at, and I would do whatever I needed to do to be up to date with reading the case law and making sure that I would be up to date with any criminal changes since I was in the criminal realm.
Thank you so much.
Thank you, Commissioner Carl.
Thank you, Commissioner. Commissioner Andy Bardos.
Good morning, Ms. Savona. How are you?
I'm doing well. How are you, Commissioner Bardos?
Good. So our paths have crossed before on the Peter Choi appeal,
yes.
Which you represented the Department of Health.
Yes.
Your background is very impressive, and the extent of your appellate experience is very impressive. I have a question about your representation of state agencies. A lot of my work is in that area as well. I represent state agencies. Other colleagues of mine in the office sue state agencies. So our office is on both sides of it. In my experience, a number of judges, oftentimes judges will be quite deferential to state agencies, and then others will be quite skeptical of state agencies. Based on your experience, how would you view a state agency litigant? How would you treat a state agency litigant? Would it be any different from any other litigant? And how does your background influence that?
I think my background doesn't influence that. I think what's important is to treat all litigants the same. And I think that's to be neutral and unbiased. I think to say, well, I have experience in the Attorney General's office, that means that 60% of cases, if they came before me, I wouldn't be ruling in favor of the Attorney General's office just because I previously worked there. Same for the Florida Department of Health or any other type of state agency. I think what really comes down to it is, what does the rule say? What does the statute say? What are the arguments that are being presented to the court? And I don't think that changes who the litigant is or how I would approach a case.
Could you talk a little bit about your judicial philosophy more broadly? And I'll leave it at that open-ended question, so you can take that wherever you'd like.
Okay. I'll see. I can be long-winded, so if you need to cut me off, then just cut me off. My judicial philosophy would be no different than what I do in practice, which is what I was just alluding to, which is to really look at, let's say a statute is at play. If it was an administrative agency, maybe it's Chapter 120. If it was in the Florida Department of Health, there were certain chapters 456 that you would look at to really see what the plain language of the statute says. That's no different with whether it's a constitutional provision, such as maybe in the criminal context, or a rule provision, which I think I've dealt with more on the civil side, is the rules and the statutes. I think an easy example of that is I recently filed a petition for writ of certiorari in the 3rd DCA, and it was a medical malpractice. It was a pre-suit issue, a Chapter 766 compliance issue, and you have to look at what that says. If the statute says this is what a reasonable investigation is defined as, that's what that's what needs to be applied by the trial court, by the appellate court, by any court. So for me, it's always been about what do the statutes say? And even when I provide litigation support to whether it was the prosecutors at the DOH or the attorneys at my firm now, if someone comes in and asks me a question, I said, well, what does the statute say? If you're asking me an evidence question, what does Chapter 90 say? you're asking me a proposal for settlement, what does Rule 1.442 say? Tell me what that says and where the issue is, because then we can go from there. So I think that if I were to be on the 5th district, I don't think it'd be any different than what I do in practice, which is to hone in specifically on that language and not stray from the language of that statute, that rule, or that constitutional provision.
What are your views on the use of legislative history in interpreting statutes?
Legislative history, as someone who has a history background, I like to read things that are historically based, but that doesn't mean I like to read them for purposes of applying them for how I would come to a decision. So I think, again, it goes back to, what does the plain language say? Are there commas? What are the other words around it in that sentence or in that phrase? And I think that's when, if something is plain and clear, we don't need to look anywhere past that. If it is ambiguous, which I think is very difficult for it to be, I think it's very easy to say, well, this is ambiguous because it doesn't reach the result that I want or the result that's best for my client. But I think in reality, things are not ambiguous. I think you turn to the canons of construction. So from my historian hat side, I would appreciate reading it just to be more well-rounded to understand that. From a judicial philosophy side and from a practical standpoint, that's not what is to be taken into account. It's really what the language itself says on its face.
Okay, and I'll ask one more question. When you're not working for your clients, when you're just in your own spare time, is there some area of legal thought that intrigues you, that you read about, that you enjoy learning about, just for your own sake?
Sure. I was fortunate enough to provide litigation support in 2 different federal cases. One was a copyright case, one was a trademark case. And those are areas that I'd really never been exposed to before. I didn't take a class in it in law school, and my background really didn't lend me to that. But that was something that I really found fascinating, that I enjoy reading for some reason. I can't really explain it other than it was wonderful. And I think one of them, it was an issue of a Day of the Dead mask and whether that was an infringement. And another one was the copying of an animal, like a figurine. And so I think I enjoyed doing that, and I probably spent more time reading that, I'll say, outside of the context of litigation, that I really enjoyed doing. I also have several books that I have yet to read, again, on my stack of things. I've started reading A Matter of Interpretation by the late Justice Scalia. I've always enjoyed his writings and his opinions. So that I hope to, even though it's a very short book, maybe at the end of the year, towards the holidays, that'll be my next read.
Okay. Thank you very much.
Thank you, Commissioner Bardos.
Commissioner Lauren Blocker.
Hello. I'm just wondering, since you've done so many appeals, if you have any areas you see for improvement, or if there's anything that you would keep in mind having litigated if you were to take the bench.
Sure. I think one area that I really haven't delved into in any of my practices has been family law. It's not something that I've had a lot of exposure to. My firm does not handle family law. So that, I think, would be something that would be different for me. When I was early on, as I clerked for Judge Kest here when he was in Osceola County, and I did get some work with dependency and termination of parental rights and seeing how that works. So I do have some experience with that, or I should say exposure, not experience. But that would be something that I would like to learn more about, because I know that that's something I see in opinions. A lot of times things are written on those, and I have seen evidentiary issues that will cross over, whether it's in the family law realm or the criminal realm, but I've seen some interesting issues there that I would like to learn more about.
Thanks.
Thank you, Commissioner Blocker.
Thank you. Commissioner Citro.
I noticed that you joined the Federalist Society according to your application this year. What led you to join that organization?
That was an organization that I think I previously was a part of. I don't recall, and that may not have been included in my application, but I received notification that Justice Thomas would be speaking at the Federalist Society conference in January. And with that, I said, this was something that I thought I was a part of. I couldn't remember if I was. So I said, I'm going to join because this is something I wanted to go to and be a part of. I was fortunate enough to go to that conference and hear Justice Thomas speak, and it was absolutely fascinating to hear him. So it was really that, and I think also some of my colleagues have been involved with the Federalist Society, and knowing what my viewpoint is on things, they said this would really be a wonderful organization for you to join because academically you would get a lot out of this because it's something that's on par with where you are with how I view cases in the law.
So you had said that, if I understood you correctly, and to paraphrase, that legislative history isn't something you instinctively revert to, which is good because in that type of meeting, one of their members like Brownlee would take you out back and you wouldn't survive the conference. On the other hand, what's the difference between that and looking at the Federalist Papers like Justice Thomas does from time to time to discern a meaning?
I think the Federalist Papers, again, I think it's looking at maybe there are words that may not have the same meaning that they do in today's day and age. So I think maybe that's what Justice Thomas has looked at them for, but to see maybe how they were used if it's not clear. But I still, again, I don't think it's something that needs to be reverted to as this is a go-to, well, I don't know what this word means, or someone's questioning this word, so let's revert to what Madison said in this specific Federalist paper. So again, I think it's something that knowing it's there in the event, it absolutely has to be there. But that's not a go-to. I think, again, it's something that you would look at only for purposes of determining maybe if a word means something different or what it meant at the time, but not what the plain language, what the intent, I should say, of what, let's say, that statute or that constitutional provision or that amendment says.
I have no other questions. Thank you.
Thank you, Commissioner Citro.
Okay, this will conclude the Q&A portion, and you have 5 minutes to make closing remarks.
Well, commissioners, I just want to again say thank you so much. This has been a true honor and a privilege to speak with you today. I don't want to keep you too long. I know you've had a full day of interviews yesterday, and I know you have a full day today followed by deliberations. But I think, again, the one thing I would like to point out that you would take away from this is my dedication not only to the law, but also to the appellate advocacy aspect of it. Again, it's something that I've been passionate about from very early on in law school. And it's something that I think my record and my experience, even though it may be a younger experience than some, I still think that it provides me with the tools that are necessary to not only be a good lawyer, but also to be a good judge on the 5th District Court of Appeals. So I'd like to say thank you again, and I have no other remarks.
Thank you very much.
Thank you,
Have a nice
Commissioner Sasso.
Take care.
Have a good one.